I think I have a big enough voice to call us to order. I certainly will find out. What an exciting day for our law school. I am thrilled to see everyone here for this incredible lecture. My name is Dana Bowen Matthew. I'm Dean of the George Washington University Law School, and my pronouns are she, her, and hers, and I am honored to welcome you today to the Fall 2024 Brand Manatt Lecture. Now, our mission here at the law school, I know nobody's read it, but I'm going to quote the first sentence of it to you. The George Washington University Law School is a global law school that exists to have an impact on the law. Today's lecture is a reflection of the fact that we are truly, indeed, a global law school, and that we are a law school that is distinguished among all 200 in the legal academy by our impact, by the power of our convening in the nation's capital, the kinds of conversations that you're going to hear today. We are truly blessed, proud and truly blessed to count the late Joe Brand and the late Ambassador Charles Manatt among our distinguished alumni who have made this lecture possible. I'm also delighted, indeed thrilled, to thank Wes and Barb Burnett for their generous endowment of the International and Comparative Law professorship that our wonderful Rosa Solario holds. Thank you for your wonderful support of our program and for our school in general. Now, I'll tell you a bit about the Brand Manatt Lecture Series. It was established in 2016 to bring leading public figures and scholars to the law school to discuss the pressing issues of international law. Now, again, another characteristic, if I dare say brand, of our law school is that we don't avoid the pressing and controversial issues of our day. It is part of our history and our legacy. Having been founded in 1865, merely 3 months after the close of the Civil War, we are a school that believes that lawyers and well-prepared law professionals are essential to the saving of a country and of democracy. Now, Mr. Brand, who graduated from our law school in 1963, was a partner in the law firm of Squire Patton Boggs, and a trustee of the George Washington University. Ambassador Manatt, who graduated from our school, was a founder of the Manatt, Phelps, and Phillips law firm. He was the U.S. ambassador to the Dominican Republic and chair of the Democratic National Committee. We're nonpartisan here, though. While both Mr. Brand and Mr. Manatt have sadly passed away, their spirit and their devotion to our law school, along with their positive impact on the GW law community, continues on through this lecture. So I'd like to also begin by extending my very warm welcome and gratitude to our speaker today, our Brand Manatt Lecturer, Mélida Hogdson. She is president of the American Society of International Law and a partner at Arnold and Porter, and she will address us today on a provocatively titled The Gymnasts, the Governors, and the Future of International Arbitration in Settling Transnational Disputes. Now, she'll be introduced in a moment by Professor Sean Murphy. But I cannot think of a more perfect lecture or topic for these times, as indeed the president of one of the most important U.S. non-governmental organizations, the American Society of International Law, is devoted to the advancement of international law and works tirelessly to confront global issues such as the future of democracy. Now, you have only to read the papers to see how important those issues are. I'm told that in this calendar year, more people around the world will vote in elections than in any previous year. Democracy is in the balance, and so we will hear from the president of an organization that works tirelessly to save it. The topic of today's lecture is the role and importance of international arbitration. It's central to our mission here at GW Law, which is educating students in the field of international law, international arbitration, and our prioritization on this field has caused us to do a few things that I want to recount for you. One, we've created an LLM concentration in international arbitration, mediation, and other forms of dispute resolution. Indeed, we have many of our students here, wave your hands, proud students, yay, here today in those classes. We've developed a broad array of specialized courses in the field, recruited part-time faculty, and facilitated the opportunity for our students to study in Paris at a university, and I'm studying French, but I'm going to get this wrong, Panthéon Assay in Paris. How close? Pretty close. Today's program is a shining example of our important role as a global leader, and it's because of convenings like this biannual lecture that we demonstrate our deep commitment to the fields of international and comparative law. Now, before I turn the podium over to Professor Sean Murphy, who is the Manatt Professor of International Law, I would like to allow him to do the formal introductions, but I do have a few key people to thank before I rescind the floor. First, my thanks to the International and Comparative Law Program for organizing this outstanding program. It was put together by none other than Professor Sean Murphy, Rosa Solario, the Burnett Family Associate Dean and Distinguished Lecturer for International and Comparative Legal Studies, Leah Calabrio, the Visiting Professor and Fellow for International and Comparative Law, and Yinzi Dai, the Program Associate for International Law. Together with Deb Gales, would you give them a round of applause? And finally, I want to extend my deepest gratitude to our event co-sponsors, the American Society of International Law, the International Law Section of the American Bar Association, and GW's International Law Society. Now it is my great pleasure and honor to invite Professor Sean Murphy, the former president of the American Society of International Law, to the podium to formally introduce our keynote speaker.
Well, thank you, Dana, for that very warm introduction of the program and of me. And it's now my turn to introduce our speaker. We're really delighted to have Mélida Hodgson here today as our Brand Manatt Lecture. I will try not to go on too long, but I want to say a few things. Vassar College graduate from 1985. I didn't check with you, but did you go into banking after college? Yeah, so she was a banker before she was a lawyer. That's an interesting fact. But she did get her JD from New York University School of Law. Early in her legal career, she was in the U.S. government. She was at the U.S. Department of Justice defending claims brought by bank shareholders against the United States. So she kind of flipped from one side to the other there. She was also an associate general counsel in the Office of the U.S. Trade Representative's Office, where she litigated international disputes before the World Trade Organization dispute settlement body, and she also provided counsel to the NAFTA Chapter 11 cases that were going on involving Mexico, Canada, and the United States. She then jumped into private practice. I won't list the various law firms that she's been at, although there are some fully Hoag folks here, so I probably should mention that. But she's currently at Arnold Porter as a partner in the New York office. In general, her practice is focused on the intersection between international arbitration and sovereign obligations. And in that space, she's represented clients or served as an arbitrator at the International Center for the Settlement of Investment Disputes, ICSID, before the Permanent Court of Arbitration, often under UNCITRAL rules, at the American Arbitration Association, International Center for Dispute Resolution, and at the Court of Arbitration of the International Chamber of Commerce in Paris. So lots of variety in the work that she's been doing. President Joe Biden, if you watch Saturday Night Live, President Joe Biden recently designated Mélida to the ICSID panel of conciliators, so congratulations for that. She's been very active, not just in her work with law firms and government, but in helping NGOs do work in the international law space, including being a founding member of the Washington Women in International Arbitration, which has been a remarkable organization. But my favorite fact about her is that she is the current president of the American Society of International Law, one of my favorite NGOs. I could go on for much longer, but I won't, except to say that it's an amazing turnout here. And as I look around the room, there are a lot of wonderful people here, but we've got the former Secretary General of ICSID, Meg Kinnear is here. I believe that the former president of the ICJ, Joan Donahue, is here. Charlie Brower, who is the former acting legal advisor of the State Department, is here. I don't know if Brian Egan made it. He's on the coming list, but the former State Department legal advisor. So a lot of people very interested in gymnasts, governors, etc. So please join me in welcoming Mélida Hodgson.
Thank you, Sean, for that very warm welcome. And I think we were going to check that everybody could hear me. Okay, good. And I do want to start also by saying thank you to the families of Joseph Brand and Paul Manatt. It's really an honor for me to be here today to speak to you about this topic. I'd also, of course, like to thank GW's International and Comparative Law Program and Dean for those kind remarks. And without ado, I will try to get into this mouthful of a topic that I selected. International arbitration, of course, has a very strong history in terms of settling disputes. That's something that I knew, but something that I also learned a lot more about as I delved into this topic. But as we know, partly or largely because of a field in which I've spent most of my career, investment arbitration, it's been under attack for the last couple of decades. And the arbitration community, however, continues to think about ways that we can do even more arbitration. And it's as if there's a little bit of a tone deafness. But you will see that by the end, I probably agree with them or agree with my colleagues in the community. But the sort of issues that we're looking at next or now or soon include human rights, as arbitration as a mechanism to resolve human rights issues, disputes, as well as the big one, climate change. And through the lens of a couple of events recently, this sort of came to me as a topic. And so, a caveat, there are a couple of caveats. The first caveat is this is going to be very US oriented because I think it would take a very long time to do a more global look at this. But the globalism comes in anyway, as it naturally would. So then the lens and the sort of original caveat that I had, the gymnast lens. So this came to me in August as I was trying to figure out what could I possibly speak about that could be something that adds to the discussion or to the discourse that isn't already being said. And for those of you who were watching the Olympics like I was, we had the issue of the U.S. gymnast, Jordan Childs, whose medal was, her bronze medal, was taken away by arbitrators. We had just in the arbitration world sort of gotten through the PD&I scandal, which was a scandal brought on really by, at least view of a justice of the English courts, the failure to act of arbitrators to recognize corruption in a case. But when the Jordan Childs story broke, it was sort of swift and furious, the reaction to it. And again, arbitration was in the eyes of the general public as something that is really bad and crazy, and who is doing this and why. The governor's lens. Well, I thought that there was a letter. It came across my email at one point, a letter that governors had signed to President Biden demanding that the U.S. not only stop including ISDS, investment arbitration, in negotiations of agreements, free trade agreements, and forget about BITs because that is obviously all about investment. But also demanding that the U.S. sort of copy Europe and remove itself from, remove the ISDS provisions from existing free trade agreements and obviously the bilateral investment treaties that are out there. And the reason I bring this up is because after doing a lot of research, both asking associates to do research, then myself doing research, I could not find the letter. And I asked someone in government, do anything about this? Not really, but, check around and you might see there are other kinds of letters. And it really was, to me, emblematic of the level of misinformation or disinformation that is out there. Now, if you look, you will find that there's some form letters out there, some of them signed by very prominent law professors and economic professors that are generated by a particular group and that is pushing this idea that we should remove ourselves from investment arbitration. So the caveat, I mentioned this before, I won't be talking about the corruption case because I think that's a whole other hour-long discussion. But the question that was posed by Justice Knowles as to whether or not that arbitrators should really ask themselves if they're fit to engage in resolving disputes that involve corruption, I think also is fit for us to ask ourselves whether or not we're prepared to really delve into an issue that is so sort of determinative of our futures, your children's futures, and that's the impact of climate change. So I decided we should ask ourselves that. So looking at where I hope to go through the next half hour or so, this is not, as I mentioned, it's something that's being discussed. The ICC had produced a report about 5 years ago on the use or the consideration of environmental claims, essentially, under ICC rules. And ICA has formed, ICA, for those of you who don't know, the International Congress of Commercial Arbitration, has formed a task force to look at using conciliation to resolve climate change disputes and essentially to create an annex to the Paris Agreement. But obviously the legitimacy issue, for those who feel that it is an illegitimate practice, can't really be ignored. And it's a little bit like trying to make sure we listen to all voices at this time in our country where we're trying to all be tolerant of different views. And I think it's really important that we look at the reasons why we're here, where this, there are groups pushing forward on something that seemingly is a good idea, very strong opposition on the other end, and again, almost like two ships passing in the sea. So I'll take a look first of the history of the use of arbitration and what I call arbitration-like mechanisms, claims commissions, and try to extrapolate from those experiences. And then I will also take a look at investment arbitration because, again, investment arbitration is the what shall I say, the beating, the post that everybody wants to beat up on, and the opposition, really the center of the opposition to the idea of investment arbitration, to the idea of arbitration being used to resolve serious issues facing us. So I'll also just take a very brief look at the reforms that we have seen over the last few years, including the ICSID reforms, to the ICSID rules, and a little bit of what's going on over in Europe. So, the Gymnasts. When the story first broke, there was a lot of discussion sort of on the chatter among arbitration practitioners. It's like, well, what does this matter anyway? It's, it doesn't even involve states. It's just essentially just gymnasts. Now, of course, we all saw, whether or not you were watching the Olympics, you saw tallies every day about who had the most medals, who had the most gold medals, and obviously, it was an issue of national pride. And in the end, the process that was undertaken did indeed involve states. It involved the United States and Romania. The complaint was made by Romania on behalf of its gymnasts, who they felt should have won, or at least one of them should have won, the bronze medal. So distilling what we've heard or seen over the course, it's quieted down, but I should say that the annulment process is before the Swiss courts now. And so they will decide who was right and how. So there are complaints about the procedure. There are doubts about who and when the interested party, Jordan Chiles and USA Gymnastics, were actually notified. It's clear that somebody under the United States rubric was notified of this challenge or question about the challenge from Romania. But apparently they learned of it, the real party in interest learned of it only about 24 hours before it was supposed to happen. It's pretty fast for arbitration. Obviously, a little bit more background. It had to be resolved before the Olympic Games closed, and this was that they were then in about a 4-day period for that to happen. The limitation on the presentation of rebuttal evidence. A lot has been made of the fact that the principal complaint was that the request to have Jordan Chiles's score adjusted because they had failed to give her credit for an element was not made within the time allowed, something like a minute or something, somewhere around there. The USA Gymnastics apparently had video showing that the request was made 47 seconds after she got off the podium. I actually watched that live on videotape, as they say, and I don't remember, but I remember. I mean, I wasn't counting because I wasn't expecting it, but I do remember that it was a fairly close period of time. It was almost as if you saw the score and almost immediately after that score changed. So I think it's plausible that it was within the amount of time. But at any rate, the USA Gymnastics said that they had videotape. Nope, can't submit that evidence. It was too late. The proceedings were going on. They also asked for a delay in the hearing. They were given 2 hours extra. So we know we have rules in arbitration. And obviously the Court of Arbitration for Sports has very specific rules because it is a process that's supposed to go rapid fire. But it doesn't look good to others. And so then people said, well, we'll appeal. No appeal in arbitration. That also didn't sit well. And then we have the issue of the fact that the chair or president of the tribunal represents Romania. And as we know, if you're in arbitration, you laugh because if you don't do this every day, that's really a bad thing, right? And he had disclosed that, as you're required to do. There's a debate over whether or not that was something that was on the list that you can't waive. That is some great fundamental right that really we're not going to allow you to say it's okay. It doesn't matter. And whether or not the right people knew that that was the case, and whether they were given a sufficient amount of time to raise an objection to that. So all of this was just very much compounded also by the fact that what Romania actually asked for was for all of them to get a bronze medal. But the decision was made to recommend essentially that no, looked like the challenge was late, therefore she was not entitled to that score, therefore you should take it away. So all of this, when you're reading it in everyday newspapers, just doesn't sit well. As an arbitration practitioner, you can probably explain away most of it or some of it and come up with a sort of, well, they're in Switzerland now. There is some right to, if not appeal, at least try to redress that. But the bottom line was,
people in the back can't hear.
Okay, sorry about that. Can you hear me now? Okay. But the bottom line is you can sense how this looks to most people. It just doesn't taste good. It's not good. So then the governors, again, there's certainly, and I remember this from my experience at USTR, a big effort to undo investment arbitration. I mean, it's been going on since NAFTA, once everybody figured out what NAFTA was doing, once California's environmental rights were being challenged, or California's environmental decisions began to be challenged, as well as other things, other decisions by U.S. government entities. It was not received well, and we went through a process to try to address some of the concerns regarding the procedures. That also faced a lot of criticism. So as I mentioned earlier, there's been a lot of pressure. I couldn't find this letter, but it, again, setting aside whether or not using ISCS for these kinds of claims or issues is feasible, it's sort of, why and why now? So the objection from the governors, if you distill it, and again, I put it in quotes because I couldn't find the governors, but I did find the professors and the legislators. So their complaints sort of can be distilled down to the fact that you have these private sector lawyers sitting as arbitrators. The fact that the obligations are so-called vaguely defined, although we were certainly at one point in the U.S. government accused of being overly defining provisions. But that still sits. And then the standard, you're giving greater rights to foreigners than Americans have in terms of these kinds of claims, and you're creating essentially these special corporate rights for foreigners. The merits, again, not subject to appeal. And the feeling that the process of seeking an annulment, which is the way you try to overturn something, is not appropriate or good enough. Then there's no oversight of these private sector lawyers who sit as arbitrators and also represent investors. Of course, that's not exactly fair because there are people who also represent governments who sit as arbitrators. So it's not, again, the sort of misinformation level is notable. And the fact that these kinds of claims, it is said, attacked labor, health, and environmental policies. There's no denying that they challenge some health and environmental policies, and in some cases, labor policies. As well as indigenous land rights. This happens a lot, for example, in mining cases, and financial regulations, as well as, quote, democratic sovereignty. I take it that goes to the ability of having elected people who decide policy, and therefore that policy should stick. And then there is damages. And this is certainly, and early on, I think, was a huge focus of the discussion, the concern, the anti-investment arbitration movement, which, the whole concept of future profits, the fact that in 20 years, you've, let's see, one of my favorite experiences, you put $5 million into a mine, you buy a couple of licenses, you don't get the environmental license, but in 20 years, you would have made $1 billion. And so that's what you should have. Doesn't necessarily take into account things that might happen in the intervening period of time. It's a formula. It's a projection. People have a lot of issues with that. So I thought then, let's go back and look and see how these kinds of processes have been used in the past. Because actually they've been used for some pretty serious kinds of claims. So I believe this is, unfortunately, the top of it got cut off, but this is, I believe, the Jay Treaty, 1794, if I'm correct. And I'm sorry about that, the title disappeared from the slide. But many credit this with sort of being sort of one of the first, or the first claims commission, the first sort of use of arbitration to address a serious issue, which is the redress for British citizens, I guess, who hadn't been paid for the damages done to them during the American Revolution. 5 commissioners be appointed. They'll choose another to decide to essentially break any kind of tie. And if they can't do that, then they'll propose, either side will propose, and we'll draw by lot to choose that 5th commissioner. Should sound a little bit familiar. And then we have, I believe this is the Venezuela Mixed Claims Commission, which similarly had, at least in this particular case, had the Netherlands as the, let's call it neutral, or neutral referee who would decide claims that couldn't, who would make the essentially be the tiebreaker in between the U.S. appointee and the Venezuelan appointee. And this was 1903, if I remember correctly. And then we have the Mexican Mixed Claims Commission, which I believe was 1923. This is famous, probably mostly to investment arbitration practitioners, because it created the Great Near Standard, a standard for the minimum standard of treatment of aliens, which has been evolved into the standard if you're what I call under the U.S. model, which is a standard that is very high. It's, we believe, derived from customary international law. And is different from a standard that until fairly recently was generally followed by European-style treaties, as I call them, which simply had that you will provide fair and equitable treatment. So it doesn't have it here, but that is sort of what we know the Mexican Claims Commission for. And again, we have a commission where a member is going to be appointed by the United States, one by Mexico, and the third by agreement of the states, and the PCA will administer. So we're starting to see an administrator now. That's a good thing. Let's see. This is the Algiers Accords. And I know that Judge Brower is somewhere around here, so I'll be very careful about what I say about the Iran U.S. Claims Tribunal. I know there's some other folks who were clerks there. These aren't the rules, but it sets up the fact that there are going to be 9 members, Iran 3, US 3, and then basically 3 from what ended up being generally Europe, which has been a topic of comment more lately. And I actually, when I read the rules, I got very excited because I thought, wow, these are really great rules. This is something that could serve as a model. And I spoke with someone who had been a clerk there and said, no, that really didn't function all that great. Don't use that. It was very dysfunctional in a lot of ways. But we'll get to why that could be. Nonetheless, I did think, and maybe in modern day, it could serve, the rules as created could serve as a model for any kind of process that would be set up to deal with these. This is the UN resolution, I believe, having to do with Iraq after the Kuwaiti invasion. Yes. And I highlighted there because I thought, oh, well, 30 years ago we were thinking about this in terms of dealing with environmental damage. I didn't go back and look to see how that has been dealt with, but it's definitely clear that we have considered that these kinds of claims potentially could be reviewed by this kind of, let's call it tribunal, panel, whatever your favorite word is. So I thought, what are the lessons from the Claims Commission? Again, arbitrators and commissioners appointed by each party, and then you choose a neutral, essentially, or many neutrals. And perfect timing, because we're getting to the Iran U.S. Claims Tribunal and what we're going to learn from it. No, and I'm going to take a water break. So again, or neutral, or you designate a third state to act as a neutral. Now, the Iran U.S. Claims Tribunal rules, of course, were based on UNCITRAL, and that made sense because there were largely commercial cases, right? Where there were contract cases. Yes, there were issues like expropriation and the standard that we all sort of use and discuss in our pleadings on expropriation. But correct me if I'm wrong, but I don't think there was any such thing as a minimum standard of treatment. But again, correct me if I'm wrong. I'm looking at you. So I thought, what was good about this and what could we learn about from it? So the structure, it's sort of like a small court. You've got these chambers. At first, when I read about the chambers and referring to a full tribunal, I thought, oh, so maybe there was something like an appeal. And again, I was told, no. That just meant that certain cases went to the full tribunal, certain cases went to Chamber A, certain Chamber B, C, etc. It mentioned counterclaims, which I thought was important. Now, the reality is, I guess, that there weren't really counterclaims. A standard on challenging arbitrators. I heard a funny story about how that was sort of applied, but it sort of raised the concept that if there are just justifiable doubts, and I think what's important about that is that it's not something where it's the arbitrator saying, well, no, how dare anybody attack my integrity? Of course I'm impartial. It's basically other people deciding whether or not it looks like you should not be sitting in a particular case. And also state-to-state arbitration existing with investor-state arbitration, because I think any kind of system that looks at these kinds of claims are going to have to do that in the future. So then let's look at investor-state and the issues that have caused so much controversy. I think we in the community sometimes forget is that, of course, we are dealing with a situation that is not merely a commercial setting. We're dealing with a state that has waived sovereign immunity, and you do that only under certain limited grounds. And I think maybe there are some arbitrators who, because they come from a commercial arbitration background, haven't always fully embraced that or understood it sufficiently. We see in some reasoning, perhaps, elements of that, and that's not been helpful. Lack of transparency. This is, of course, a big one. You're dealing with state money, funds, public funds. People need to know what's going on. Now, I know from my own experience that there are a lot of states that actually don't want transparency, and I see Meg nodding because I think ICSID was a little surprised by how there were states that didn't really want full transparency. That is something that has to be dealt with, and we have, I believe, an UNCITRAL or a UN convention out there that hasn't been signed on to by a lot of states, including some fairly developed states. That is a transparency provision, a very detailed convention. Then we have the arbitrator designations, the perceptions of bias against states. Of course, on the other side, there are a lot of folks who represent investors who feel that there's also bias against investors. And then, I mentioned this, there may have the procedural skills, some of these arbitrators, but generally don't necessarily understand how governments operate. I'll probably mention this again somewhere, but I was speaking yesterday with a lawyer for a government that shall remain nameless, who was complaining about being required to produce deliberative process documents. And again, I say no state signed up for that when they signed up for either a 7-page treaty or the 35-page version, thinking that that kind of obligation would be imposed upon them. So then, let's see. transparency, da 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 da. Okay. Then the no appeal. Again, this is throughout. And the counter argument to the fact that there is no appeal, of course, is that an appeal would cost more money and take too long. And how do you decide exactly? Is it going to be just a fact issue where you got the facts wrong, or is it the law? You know, what standard do you develop? I think the latter question can easily be determined. The cost question, I guess the counter to that is, so what? The time question is, these things take long enough anyway. Maybe there's a way to figure out how to make all of this go faster, and maybe that's the question that should be examined instead of the fact that, you know, we shouldn't, or instead of saying we shouldn't have it because of these objections. And generally, there is the issue of what many feel is a lack of deference for legitimate public policy decisions, and the fact that it results in a chilling effect on regulation. I think that's an issue that's very heavily debated, and I think it may actually depend on the country that you're in. But that, you know, that kind of, on the one hand, you say, okay, well then it's not that that's the situation everywhere, so why does it matter? On the other hand, oftentimes it's in countries where you don't want a chilled sort of regulation in public interest. And I'll say that one thing that I remember around the time of the Philip Morris case against Uruguay, which I was not involved in, some of my colleagues were, but, and I'm fairly certain this was all public, there was some, you know, the Uruguayans apparently who have, you know, so it was, you know, the packaging, put 80%, 90% packaging showing how awful smoking is for you. There was also the issue of the fact that they have sort of a dual Supreme Court, I'm going to paraphrase it that way, system where you may get to the highest level of one and it says one thing, and you get to the highest level of the other and it says another. So that was another issue there. But the Uruguayans, when the case was first brought, sort of said, okay, all right, we'll give up, we'll change it, we'll get rid of it. That caused a lot of uproar in the NGO community, and precisely that, see what happens is instead of, you know, regulations that are meant to protect the public, they're going to give up because they've been sued. And tobacco-free kids came into the rescue, Michael Bloomberg. And then again, there's damages. I must admit that I have often referred to this as a sort of voodoo economics, because some of the theories are just really, quite frankly, outrageous. I will say that I think I have seen over the course of a couple of decades much better work by tribunals in terms of looking at, analyzing, putting the experts and their lawyers' feet to the fire on this kind of an issue. There was a case against Mexico recently where I think they were claiming, I don't know, billions of dollars, and got something like 34 million, which wasn't even going to cover the costs of their lawyers and their experts. So we've evolved, and I think arbitrators have evolved. But this is still the idea that you may have damages that result in a huge percentage of a country's GDP is something that people feel is wrong. So then, what are we talking about? We've talked about the fact that you can have arbitration used to resolve armed conflict. A lot of the disputes from the early claims commissions came out of armed conflict. You'd think that's incredibly serious, so if you can deal with armed conflict, you should be able to deal with something like climate change. We have seen cases on the environment in ISDS. We've sort of seen cases on human rights. And so again, the question sort of is, how are we going to deal with climate change? And I mentioned the Philip Morris case. The Urbacer versus Argentina case dealt with a license regarding water concession. Again, people feel that water, which I probably agree, is sort of a fundamental right. Of course, others will say, well, it's the state's obligation to provide that, and if they contract that out, then, the state's responsible for that, and responsible if they violate a contract or breach a contract. Nonetheless, this is the kind of case that causes people to say, why is this tool being used? With all of its deficiencies, why is this tool being used to resolve this kind of issue? And then the Bear Creek versus Peru case, where the indigenous people protested to the extent that led to the shutting down of a mine. And in the end, the investor, again, this was an example of a tribunal really delving into the damages and awarded only, I believe it was the sunk costs, so something like 18 million versus hundreds of millions of dollars that were sought. But again, people will say, well, why do we even have that? But there was a concession, and the way that that's sort of what happened in the end. But it again raises the issue of, is this the kind of claim that should be discussed or resolved by these, private actor lawyers, private sector lawyers? So we have reform going on, as I mentioned. We have the UNCITRAL Working Group 3. We have the ICSID rules that were amended after a process that took a few years. And we have a European proposal to create a court, which is sort of part of the Working Group 3 work, but nonetheless also stands on its own in some ways. One point to make is that none of these processes can or will address by mandate substantive provisions. So some of the issues that have caused the most pain, like fair and equitable treatment, minimum standard of treatment, cannot be addressed by these groups. And that's an issue that I think will remain problematic, because that's, if you don't have an MST claim that is easier than an expropriation claim and will give you the billions of dollars, then you don't have the problems that people complain about. So I'm going very light on this because there is a lot in those reforms, and I commend anybody and everybody to take a look at them. But I thought, what are the important things that, in terms of what we're speaking about today, that we can highlight? Transparency. Awards, orders, and decisions essentially are going to be published unless you object. I think I got that right. Then we have non-party submissions, sort of something that we looked at in the US some years ago, and open hearings, which obviously allow for a greater participation by the groups that are interested in this, and not just the lawyers for either side. A code of conduct, which was done with the UNCITRAL Working Group 3, and essentially addresses the issue of double hatting, which is a principal issue. Yes, they're private sector lawyers, and the complaint that they are sitting at the same time that they may be arguing cases with the same subject matter. I think for some U.S. lawyers, that complaint sometimes seems a little bit light in the sense that, as U.S. lawyers, we argue sides all the time. But then the response to that is, but you don't sit in judgment on it. It's an issue. Third-party funding. There's a debate, of course, as to whether or not third-party funding has led to an increase in investment arbitration cases. ICSID requires disclosure of the existence of third-party funding. It does not require disclosure of the actual contract itself. That is where some wanted to go. I think that, from my point of view, the issue there is really, does it impact the process and the proceedings? I do think I've seen it impact the process and the proceedings, but it's a case-by-case basis. But the sort of desire to, we're not going to get rid of third-party funding. I don't think that's going to happen. And it's an industry. It's there, and there is an argument that it allows claims that couldn't otherwise be brought to be brought. I will say that We have looked at claims. I've looked at claims that are small, and there's nobody interested in those. So query whether or not it's really an access to justice solution. Fact-finding provisions. Again, the issue that the substantive interpretations and conclusions that there were substantive interpretations of the treaty provisions obviously cannot be addressed. They're treaty provisions. ICSID doesn't have control over treaty provisions. And the fact that there's limited participation still by non-parties. There's some who believe that it should go beyond that. What you have essentially are sort of NGOs with particular interests who intervene maybe in certain specific cases. In some ways, they're similarly situated as the claimants because they're funded, as opposed to your average maybe perhaps small group, maybe of indigenous people in one particular place who don't have access to that. So, and obviously tribunals can't hear from 100 people, although there's some who say that maybe they should. And then we have no appellate mechanism. Again, that's not something that can be done. It would require changing the convention. So then we have what's in CETA, which is the Canada-Europe agreement, but is essentially the proposal of the EU. And it's essentially to create something that looks like a court. And it would include an appellate mechanism. There's been, these are under negotiations. I don't think it's even set up quite yet in CETA, but they continue to work on that. And I think once that happens, because it probably or may happen before Working Group 3 finishes, we'll see. And obviously you need cases to see how it actually works. So my conclusions on the reform movement, there are going to be people who hate this, and nothing is ever going to be, short of getting rid of the system, nothing is going to be acceptable. We have to acknowledge that. And then for other stakeholders, as long as there are not changes to the substantive provisions, because if you don't have an FET to interpret, then you can't find that there's an FET violation, and you can't give $1 billion based on an FET violation. Then you're not, it's going to be hard to get there. But I do think that the revisions to treaties, certainly it's a process that we went through in the US in the mid-2000s, and subsequently even European treaties, have come to give greater recognition to public health and welfare concerns. Now, there's some who say, okay, but all that's been done is the same thing essentially that you had in a US FDA from 20 years ago, which said, you shouldn't lower your standards to get an investment. You shouldn't lower, labor and environmental standards. The true test would come if you said, if you violate labor and environmental standards, then you will be liable on some level, or if you're bringing a claim, that will count against you. I don't think we're there yet. I think I can't remember them now, but I think there probably are a couple of treaties out there, models out there that propose to do something close to that. And of course, we know that in US FTAs, it's not under the environmental chapter, but it's under labor chapters. There are proceedings that allow for challenging actions of corporations. Am I right about that? Okay, good. So again, I do think that our models today have reflected greater civic engagement, and the CETA model, I think one it's an evolution of the World Trade Organization model, and I think that's problematic for a lot of reasons, in the sense that what we thought 20 years ago, 15 years ago, and I recognize there are people who will still say this, but what we thought was a great model obviously has sort of crumbled, and at the end of the day, if you have political issues, it can only work so well or it will not work. So the lesson from there is it seemed good, but it needed some work, and I know they're working on it, but we're not there. So then we have the code of conduct, transparency provisions. So those have addressed some of the concerns. So in terms of my conclusions, You know, again, we have had these kinds of systems for centuries, and they have addressed very serious issues that needed to be resolved among states. And they involve essentially states providing for private sector parties to be able to use these processes to resolve their issues. But we have a system that is still largely a commercial process. And I do think that reflects a lot of the concerns. It's query how we would structure this where you have climate change issues. And I think that when you have, it isn't simply that a government says, one of the arguments that is made is that, well, there's going to be a lot of investment that's going to be necessary to meet the climate change goals. And states don't have that money. It will have to come from investment, private investment. That's true. On the other hand, you have huge subsidies. We have something called, I believe it's the IRA here, huge public subsidies. And so that has to factor into it. It's public funds. And I think any arbitration vehicle that's going to resolve disputes that involve state funds should be constituted in a manner that does protect the public interest. And if we're going to use the existing models, we cannot ignore that we're dealing with a waiver of sovereign immunity. The alternative is you can go into court and take your chances. So it's not as if there are these independent rights out there. There are rights that are specifically granted. So any kind of new model, I think, would have to balance those issues of sovereignty, and would have to have some kind of what I call real jurisdictional gatekeeping. I think one of the disappointments for those of us who worked on the CAFTA and the various U.S. agreements that came out of the mid-2000s is that a provision that was really intended to speed up processes and to say, look, if you don't have a real claim, you're out of here in a short time, has not quite done that. And I can tell you that especially in the world of states choosing lawyers through procurement processes as if you're the guy who's going to fix their bathroom, means that you're going to the lowest common denominator, and we're increasingly getting there. And that means that you make decisions. You make a decision that 2/3 of a chance we might get this knocked out, but I've only got X amount of money, so I'm not going to go there and query whether or not that's good for the system. But it still remains, I believe, that arbitrators are reluctant to knock cases out. And so that, I think, is something that would have to be looked at if there were to be this kind of a system. And then I have a couple of experiences that I'll share. The Bilcon case. We haven't quite gotten to this yet. But I remember I was representing Venezuela, and we had a case where the claim was for a few $1 billion over a mining permit that was not granted, and there was some dispute. The language was in the treaty was, consistent with international law or something to that effect. So again, we interpret that as being customary international law. That's the argument that we make, and it was a Canadian treaty coming out of the NAFTA era, and I remember going to speak with folks up on the Hill, and I said, you've got this case pending, and you've got the Bilcon case. I can tell you that we've had a result in a case where they kind of just blew aside this idea of customary international law and interpreting it under the minimum standard. You should think about that because it may affect you someday. And Bilcon came out, and they kind of brushed it aside. And then Bilcon came out, and the tribunal kind of basically said, Yeah, you did a lot, Canada. That was a great process you set up, but we still think there's an FET violation. It was then that folks started to take notice and say, wow, maybe we really need to put in something in these treaties that basically say the standard is minimum standard. It has to really shock the senses in order to be a violation. And let me be clear, I'm not talking about things like expropriation, whether you're, going in and actually physically taking something, or even the other realm of, aside from MST, that has caused a lot of issues, which is the indirect expropriation, which usually targets regulatory decisions. Not even there. So, this, I think, it was too. I really think that was one of the decisions that led to the downfall a little bit of CPTPP, or it was whatever it was called before that. Because it was just sort of, this is the kind of decision we're going to be getting. When we have this language in here, then, this is not something for us. Obviously, there are a lot of factors, particularly political, change in U.S. government, et cetera. But it started to really have, let me put it this way, states other than Venezuela look at this and say there's something wrong here. Counterclaims. There is an issue about the fact that, treaties don't provide for counterclaims. They're not set up to do that. Some treaties have a little bit of wiggle room. You might be able to make an argument that really it was intended to allow any party, not just the investor, to bring a claim. Those are about 4 treaties, perhaps. And you can try to bring a counterclaim, particularly for environmental damage. We tried to do that in a case, and you're going to get shot down because, it's up to the tribunal to interpret whether or not you can read that wiggle room as a pro. I've also experienced counterclaims in the sense of, in terms of what we're speaking about today, where you really are looking at climate change issues. I worked on a case that involved an infrastructure project where it was a commercial case, so it was a contract case, and you could, it did involve a state, but you could bring a counterclaim because one of the objectives of the contract was to address the state's need to lower emissions. It's a state that has horrible traffic in its capital. And we brought in damages experts who had worked at the World Bank, and sort of, at first it seemed crazy to me too. They're like, yeah, no, if you do this, and this, this potentially the state, because of the delay in the construction, has probably lost about $1 billion in benefits. And I remember sitting here like, really? And we spent a lot of time thinking about, do we even want to make this counterclaim? But we had promised the state we would, and so we put it in, and the arbitrator's eyes were sort of like polite acknowledgement that we had the right to bring it, polite recognition that it didn't sound too much like voodoo economics, but absolutely no reaction. And so we did not win that counterclaim, obviously. But again, it's emblematic of, is it fit for this purpose? And a year ago at the ASIL mid-year meeting, I walked in on a panel that was talking about essentially how to measure damages for loss of water rights. And I thought, oh my God, this is real. There are people doing this every day, which of course the experts we had worked at the World Bank and did it. And I think there is an educational gap in certainly the current cadre of the arbitrator world, that I think that kind of knowledge would need to be addressed in any kind of real process set up to deal with this. And then finally, before I get to the final recommendations, I would say the issue that's really bedeviling states right now is big, expensive American-style discovery, which has definitely made its way into investment arbitration. I've spent 1.5 years on a case recently on essentially discovery. And again, I had a conversation with a U.S., shouldn't have said that. You didn't hear it. A government official who complained about the fact of being required to produce deliberative process documents, and essentially an arbitration tribunal deciding that a process that involves agencies other than that particular litigating agency, that there was no privilege around the documents. That's problematic, because quite frankly, I'm not sure that that is for those people to determine. And they don't have the knowledge, they don't have the background, and most have never worked in a government. And so that is, I think, another issue that we'll need to be thinking about. So I do believe that if you can tackle issues coming out of a war, that you can indeed tackle climate change. And we've seen the evolution at each stage of addressing or adapting to contemporaneous needs. And after all, arbitration is supposed to be flexible, so it should be able to do that. But again, the current commercial model, I think, is not suitable. And I think there would have to be changes that would need to be made. There would need to be clarity in whatever the substantive obligations would be. And obviously, this is different from an ISDS treaty, and one would have to think about how you deal with that. If you are perhaps, again, let's say there were to be a new fictional IRA, and you're saying to a foreign investor, you too can benefit from this. Maybe the provisions that the conditions around that are, here's the model of where you can go if you feel you've been wronged in anything, and it's not that route. That still, I think, remains to be seen whether or not that could be designed. But I think you would need to have substantive provisions that were clear about what the obligations were on the part of the state. I think you would need to have transparency in a model that means everything essentially gets published. I personally think I had an experience where, in a case involving corruption, and just really nasty briefs from the claimant side, we temporarily published our counter memorial, which we were allowed to under the procedural order. And there was a technicality about the consultation process. It's only up for a few hours, but it brought the claimant to, we disclosed proceedings, we disclosed the results of investigations that we had done on the claimant's corruption. And amazingly, they wanted to settle after that. So transparency, I think, really helps. And I think it has to be there. And I think it just answers a lot of the questions. I think we remember from the first few NAFTA cases where once they set up a room with a feed, you sort of had, okay, maybe the first day it happened, 100 of the people who, really objected to this showed up in the morning, then 50 in the afternoon, then 25 the next day, and then, you're down to 5. Because it really isn't just a bunch of people getting together in a hotel room trying to, undermine the public good. Qualification of arbitrators. So this is a much bigger issue. I think it's not just an issue of whether or not you work mostly from one side or the other. Quite frankly, I think that I do think you limit the pool by some of the rules that are set to avoid someone who's actually been in the private sector, and I admit to an interest in that, but I do think it does affect the diversity of the pool. Counterclaims. I think you have to have counterclaims. I think that also controls whether or not someone actually brings a claim. If you know that you might be subject to either a set-off or also damages. And because I think it's just right. In a transactional relationship, there's always two sides to what went wrong. And if the other side has a claim, it should not be denied, particularly, again, where you're dealing with state funds. Document discovery, I mentioned that. Better understanding of damages. As I said, I was a little surprised myself last year. I thought, wow, there are people who are really working on this. And of course they are, because there were commitments that were made under the Paris Accords. And somebody is calculating this. And it's not that difficult to understand. And I almost think that there also needs to be qualifications of experts. I think, something like a Daubert standard may not be that far off. It's used for science, so why not use it in these kinds of circumstances? Because some of the claims are really just ridiculous. And they're better at sitting there and talking to a tribunal maybe than the other expert. But I do think that's an issue that would need to be understood, or limitations on damages. And finally, an appellate mechanism. I remember the negotiations for the CAFTA, and sort of what I thought was at the last minute, we got an instruction from up on the Hill that we needed to have an appellate mechanism. Like, that was what was going to do it in terms of getting approval. Was not very happy about that. They decided I shouldn't be one of the people talking to the staffers on the Hill for my lack of diplomacy, which was fine. And we put in something that says, in 3 months we're going to talk about this and we're going to get it done. It's never been done. It's never been done because even the staffers don't want to get it done. It's difficult to do, but I think 20 years later, perhaps we evolved to a point where we can think about these things and figure it out. Will it delay? Yes, it will delay. But that's, there are many aspects of justice in this, and it's not just the private party going as fast as it can to get rights. And as we know from our own experiences, sometimes delays are caused really by the parties and their lawyers. So it's not as if there aren't delays in the process. So I will stop there. I've probably gone way too long. Sorry. Sure.
So I think we have time for a couple questions, 2 or 3 questions. I'll start right here with Ron.
So, thank you, Melída. I just wanted to say you started off with this mysterious governor's letter.
Yes.
And I thought it interesting. Interesting that somebody asked me to comment on a draft of something that looked like what you're talking about, and I won't say what the organization was, but it was basically something that asked for all ISDS provisions to be removed from existing U.S. treaties as well as any future ones, of course. And the idea was that it was for climate issues, that companies could bring billion-dollar claims against states, but the states had difficulty, as you said at the end there, with counterclaims with respect to environmental damage, shall we say? So that was the thrust of that particular, which I think is the letter you were referring to, and I was asked to comment on it, and all I can say was I think the nicest thing I said was that I thought it was simplistic.
It is indeed a very simplistic sort of argument, and again, a solution to that, of course, would be to allow everybody to be able to bring claims, not just the investor or the aggrieved private party. But this is sort of copying. I mentioned copying Europe, and of course, the difference is Europe technically is like a United States, right? It basically said, we're the United States of Europe, and we don't need to have Montana have an investment treaty with New York. That's essentially what the EU was saying. It's a little bit different when you're a state that has really a relationship with other sovereign states that aren't under any sort of agreement with each other. I mean, so I think it is very simplistic to say, because one of the justifications is that, Europe's done it, so why can't we? And of course, we don't always follow what Europe does anyway. Yeah.
Jacinda.
Thank you, Mélida. You've talked about substantive obligations, and of course, those can come from treaties, which states make, and so they could fix some of these issues that you've highlighted if they wanted to. But many people have suggested there, in the wake of some of the criticisms that you've discussed, that there may be a move towards more investment contracts between states and investors. So I wonder if you might share your thoughts on what, if that shift does occur, what that likely means more systemically, and what should be the key issues to focus on in that shift.
Yes, and of course we have UNIDROIT and the ICC looking at coming up with a model investment contract. And I think some of the concepts that I've talked about would apply, and that is, again, that it really has to allow for claims on both sides. And my understanding is that something like that would essentially be purely contractual. There would be no issue of a treaty claim. And I think so much of the unhappiness with ISCS, of course, is that you have a determination that a state has violated a treaty, so that's already one thing, and that it's done at a sort of very general level that it's violated a treaty. No state likes that. There are states that are very concerned about their so-called ICSID score, and it's not a score that ICSID does, but it is a tally that people have of, what states have what. Of course, there's some states that don't really care about that, so that's also a counter argument. But then there is the issue of having provisions that really should be balanced in terms of being able or rather, let me back up, the concern about saying that you violated an FET provision. In these contracts, you wouldn't have that. In these kinds of model contracts, obviously, you wouldn't have that. So that takes away some of the sting, but I do think that there's still the issue of having violated some kind of a contract. But again, the states are part of that, so should be able to ensure that it is fair and balanced. You mentioned, states are the ones that have the substantive provisions and can, renegotiate. Unfortunately, states move very slowly, and even states that have been very much affected by these provisions, and that have, let's say, some of the Latin American states that have lost a lot of these cases. Either there's not the governmental structure right now to deal with that, or desire to deal with it. I mean, I think, I've said to states, talk to the U.S. government. I think the U.S. government would be happy to discuss this. Now, of course, there is also a process in the U.S. government, which means this doesn't happen immediately. And I think that's also one reason why, this push to take ISCS out of existing treaties, I think it's simplistic also in the sense that it ignores that there is another side, and that the U.S. government has to respond to many stakeholders, not just when it's sued, and particularly for the U.S. government where it hasn't lost a case, it's a little bit difficult to say there's all of this damage being done. Obviously, the issues of regulatory chill impact some of that, but then all the more reason to revise and adapt the treaties. I think we had one back there, but then we'll come back to you.
What's the difference between the European CETA model and the Permanent Court of Arbitration in The Hague? Isn't there already a model there in Europe for that?
There are probably people in this room much better able to respond to this. So the CETA, first of all, is set up in an agreement. It's not active, it's not real, it's not existing. The Permanent Court of Arbitration handles or administers cases that have been brought under multiple treaties. So, for example, as long as a treaty provides for, let's say the U.S. treaty provides for UNCITRAL rules, then the investor can choose to have that administered by the PCA. But the PCA itself doesn't, it's not a set of rules. It's quite, I guess the CETA would be competition for, if it were ever to get going, the sort of world court on arbitration, it would be competition for the PCA, in the sense of you would go there instead of using their services. Dan.
Thank you. Thank you very much for this presentation, which raised a lot of terrific issues. I thought one of the elephants in the world is in the room is this qualification of arbitrators. As you're talking about cases that involve human rights, environmental issues, human rights that area is pretty difficult to understand on its own. I would argue that environmental issues are much more difficult. And at the Bocconi program in the spring, I asked how many people in the room, this mostly arbitrators, knew what ecosystem services are. That idea is the idea that leads to the conclusion that nature is actually the infrastructure of society. There were two people. One was this lady, and the other was a student. And I submit, arbitrators who don't understand that really are not competent. I think that's part of what you're saying too. And so the question is, how do we deal with that, both on the human rights side and on the environmental side? And I'd be curious if you have any specific ideas about that. Thank you.
I must admit that when I thought about that, I thought that, well, arbitrators are going to have to go to a school. They're going to have to go to some kind of school to learn some of these issues, because I agree, particularly the way these issues are presented in cases, you may not have, you're getting the parties' version of it. You may not be getting the whole version. And obviously that's where NGOs come in and why we have amicus curiae submissions. In this kind of a structure, setting aside ISDS, it may be that you would have arbitrators who are not necessarily those private sector lawyers, or frankly, professors who are also the private sector lawyers in essence, but don't have the stain of being at a firm, let's say, but who are actually experts in these areas. Some would say, well, you can just hire experts. Well, why do you need to be a lawyer to do some of this, quite frankly? And so I think there are a couple of ways to address it. One is to ensure that you have a true expert, substantive issue expert on these kinds of tribunals, and the other is to have arbitrators learn about these issues before they can sit in these kinds of cases.
We ignored this side of the room. Any questions there? Maybe one more question?
Okay. One hand went up afterwards, but we'll go there first.
Presentation. I'm a LLM student, so I'd like to ask you, as you spoke about the big issue of the corruption issue that is not very accepted in the arbitration, or people think that arbitrators should not cover this problem. But we know that there are a lot of cases and a lot of situations when investors lose their businesses because of the corruption, and it's not more favorable treatment or it's MST. It's literally corruption that is the issue of the challenging and the takeover of businesses. How should an investor present its case in order to be granted on these grounds?
Sure. So I think the issue is that you start with corruption being both ways, and that's the problem. We had one, the case that I mentioned that I was involved in, the investors, first of all, had been sued by their co-investors in public, in courts, so it was public. That's where we started to look, that they were not exactly clean. They didn't have clean hands. Now, the argument is usually that the state doesn't have clean hands, and so therefore the state should pay for any kind of corruption. But it's difficult when it is a two-way street. And I think the issue that arbitrators have to deal with is you can't just say, oh, that's a complicated issue, or we don't have the resources, we don't have the ability to look at that. There are, there are corruption indices, there are guidelines, red flags. Cinda's done a lot of work on that. There are resources out there to address that. And I think the main point about it is not that arbitrators can't necessarily. The question was posed, but the answer to the negative answer on that is you can't handle it if you don't do sort of basic work on it. And you can't just say, oh, we don't see it. I mean, I also worked on a case where you had the party that admitting, this was Odebrecht, admitting that they had bribed certain government officials for contracts. And At least one tribunal sort of said, and the particular government involved was going through a very slow indictment process. That's their system. And you had a tribunal basically say, well, you know, they haven't been indicted, and, you know, it's not enough. And that's problematic. And I think on corruption, we'll have to move into a world where arbitrators do more and have to be able to justify better decisions to say either there was no corruption, make that finding, but not that we just don't have enough to deal with it, or to find that there was corruption in the party that was also engaged in it. Neither party should benefit probably, but certainly if you're the one that gets to sue and bring a claim, you don't get rewarded for that. And I think that's the issue.
So last question over here.
Hi, so my question is about the appellate mechanism as part of the reform.
Yeah.
And since arbitration as a dispute settlement mechanism, you know, the appeal of it is that it's quick, it's less expensive. So how do you balance that appeal to arbitration and as possibly a criticism to the appellate mechanism? And if you've seen that already.
Simple questions you're getting.
So how do I balance it? I think that at this point, after 20-something years of considering an appellate mechanism, the same complaints pop up and are going to continue to pop up unless we can address them. The sense that a standard that basically says the only way we're going to overturn a decision that many feel is very wrong is that you manifest disregard for the law or whatever it is, some version of that, or corruption on the part of the arbitrators. That's kind of, that's an almost impossible standard. And, the question is, should it be that if you get the facts and the law so wrong, maybe it doesn't, manifest disregard is sort of, you're kind of ignoring it, basically. There has to be something that is less than that you can have as a standard. And the reason for that, again, goes to legitimacy. That there are parties, and particularly when you're dealing with these kinds of cases, that just don't feel that that's a legitimate standard. Because it's an alternative that's been offered under a waiver of sovereign immunity. And if you're in a U.S. court, or maybe another court, you wouldn't be able to get away with that. So you would have the right to appeal, and yes, and I think that most parties would appeal any kind of award, yes. But the value of the justice of it, I think, particularly in these kinds of cases, outweighs that. And again, there are delays for many reasons. So this is just another one.
So I'm really delighted we've resolved all of these issues. It's been a very good, but I'm joking, of course. It's been a wonderful array of issues that you brought before us, and I don't know about the ICSID score, but I will say on the GW Law score, you've done extremely well. So thank you so much for coming. So we do have drinks in the back of the room there for folks. Feel free to grab that. Is that where it is? Yeah, in the back of the there's also food in this room, or maybe drinks too. So whichever's closer to you. Thanks so much for doing that. It's a tough set of issues. Yeah, very much so. Yeah.